versus Westfield Insurance Company et al. Good morning, counsel. Would you please just state your name and announce your readiness to proceed this morning for the appellants?
Good morning. This is Carrie Evans on behalf of the appellant Westfield Insurance Company.
All right, good morning. And who is on behalf of Nair?
Good morning. This is Amanda Leffler on behalf of Al Nair. Just a quick question for the court. Are you able to see me?
Yes.
Okay.
You have a lovely picture behind you. It looks like a golf course.
Wonderful. I can't see you, but as long as you can see and hear me, I think that would be just fine. Thank you.
Okay, great. All right. I wasn't sure if anyone from Berkeley Insurance was on this morning.
Yes, Your Honor. John McLaughlin, Berkeley Insurance Company.
Okay, thank you. Ms. Leffler and Mr. McLaughlin, do you all intend on both arguing this morning?
Yes, I will be taking the first 12 minutes of the argument, and Mr. McLaughlin will be taking the remaining 3.
All right, excellent. Just as we all know, in the new norm, we don't have buttons or lights, so I'm just kind of keeping the time here. And if you get close to your time, I'll try and gently interrupt you and let you know that you're at your time. All right, thank you. Ms. Evans, did you wish to reserve some time in rebuttal?
I would. If I could reserve 3 minutes for rebuttal, I would appreciate it.
Okay. All right. Then when you're ready, Ms. Evans, thank you.
Thank you. May it please the court. Good morning. As I indicated, my name's Carrie Evans. I represent the appellant, Westfield Insurance Company, who is the insurer of the appellee, Al Nair. We're requesting a reversal of the trial court's entering of summary judgment in favor of Al Nair and its declaration that there is coverage under our policy for a loss, which we will discuss. We submit that there are really 3 points that support the reversal of the decision of the trial court. The first being that the work of Al Nair in this particular project in directing the demolition of what was a King's restaurant was not an accident, would not qualify as an occurrence under our commercial general liability policy. We submit that the interpretation of the term occurrence within our policy should be pursuant to the Supreme Court precedent that exists at this time under the Custom Agri decision and the Ohio Northern versus Charles decision.
Well, Ms. Evans, the first time that I read through this, the first thing that struck me was I thought, that this is just a unanticipated consequential damages case, which seems to be pretty common in these areas. Why isn't that so? What's your position on that? Why was this foreseeable?
The work of Al Nair with regard to this restaurant, its job was to procure for its customer contracts with subcontractors to carry out a construction project. Weirton Medical Center contracted with Al Nair to provide services as a real estate developer, designer, contractor. As part of that, they were required to contract with subcontractors, schedule subcontractors, make sure all of those steps were in order for this work to proceed. They also held within their hands and controlled that right to push the button and say, proceed with that work. Al Nair recognized its own business risk in the type of work that it did, that it could never proceed with that type of action until it had an actual contract in place with its customers and a right to proceed with the project. It's their job. It is their work. To say that it was just a mishap says you can run your business pretty much any way you want unchecked. What we submit is that Al Nair had a responsibility and had knowledge within its business of what it needed to do, those steps it had to go through, and it failed to do so, and that's not an accident under Ohio law. Instead, it is a business risk and something you put precautions in place internally to protect yourself, which Al Nair, the testimony of the witnesses is they did have that type of a system in place, that this particular project manager should not have done what he did. It was against company policy. He did make a decision to go forward knowing he did not have a contract in place, but he thought he was close enough that he could pull this off and everyone would ultimately be happy in the result of what occurred. As far as there being consequential damages, my argument today, I wanted to move and talk about our exclusion. The J5 exclusion within our policy specifically provides that there is no coverage under this policy for property damage to that particular part of real property on which you or any subcontractors working directly or indirectly on your behalf are performing operations, if the property damage arises out of those operations. That is specifically what happened in this case. Al Nayer's operation was to hire a subcontractor, tell them when to start their work, carry out the exact work that was done at this particular location. And our policy says that is not covered under that exclusion. Of course, that skips ahead and skips over whether or not the policy was ever triggered. But I do believe that the exclusion is something the trial court never really focused on. We got very tied up in the trial court on the custom agri argument and how this isn't a workmanship case. And should that precedent really apply? And is this an accident or was it just a real mistake? And we never really focused on that exclusion.
Well, what's the test? How are we supposed to analyze this to test whether or not that who controlled this business process, and what do we look at to determine that?
I think you do look exactly, the question is part of what you've asked me. How do we determine that? We look to see who is controlling that process. Who was the one that had the control and the opportunity to foresee what needed to be done and those risks that were directly related to failing to do it in a specific manner. In this case, the control was held by Al Nayer with regard to this project. It knew what it needed to do to protect itself, which was to make sure that it had a contract in place before it proceeded. It foresaw that if they didn't have that in place, there were foreseeable risks. We did discovery in this case to identify exactly what Al Nayer was aware of and what they knew, which I think is important. Al Nayer was aware that this particular restaurant was owned by a third party. It wasn't owned by Wheaton Medical Center, their customer. They were aware that Wheaton Medical Center themselves were in negotiations to obtain the right to lease that space. The vice president of Al Nayer acknowledged he knew there had to be a release of the existing lease before the project could go forward. There was a delay. Al Nayer was waiting and waiting and waiting for its signed contract, and there were some discussions about what are we waiting for. Al Nayer knew that there was a third party involved. They knew that they couldn't proceed with this work. You can't go onto someone else's property. We need to wait. But they were ready. They were standing at the ready to do this work. They were in control. And I think that is the most important thing to look at. It's not intent. I disagree with the arguments that have been made by Al Nayer that whether or not something is accidental requires some type of an intent test. Did Al Nayer intend for this damage to happen? Did they intend to hurt a third party? My position is that it's not truly intent. It is control, who controlled the steps that you needed to follow, and was this a foreseeable outcome within their control? We submit that both of those were satisfied, which says this isn't accidental, that this isn't a mistake. This was a business decision, unfortunately made by an individual who got fired for it because he didn't follow what were internal company policies.
And didn't Al Nayer also know that there was no contract between themselves and Wheaton Medical Center?
Yes, yes, they did not have that contract. Everyone at Al Nayer was aware that their contract had not been signed with Wheaton Medical Center. The vice president indicated that that would be the signal for his project manager to go forward, that he would physically deliver that contract to the project manager. So it wasn't just verbal communication. Their internal checklist required physical handing over of a signed contract before this project could go forward. A good business practice.
Right.
Certainly something.
And what I found interesting is, this is governed by occurrence, and under the Supreme Court, it's governed by this fortuitous sort of definition. And so or fortuity. So, but also what I found really interesting in light of the facts of this case is that even though Al Nair was engaging in what is within the sort of activity that is within their business, but it wasn't like business activity because there was no contract to do it.
It really, there are bizarre facts.
Yeah,
And
so
at
so in
this
other
case-
words, the policy is intended to cover business activity, meaning that the person is engaged in their business, meaning that they have the authority to do whatever they're doing, right? And so in this case, there was no authority. So I just found that sort of interesting.
It is, and I think the thing that the facts in this case make it a very unique case. It is not a case that I think anyone will be able to point to and say, look at the facts of that case. It's just like our case, and this is going to carry on to other matters and expand definitions because it is quite unique.
Yeah.
With
You
regard
know,
to
I'd
the
like for you to
involvement
go back and address the exclusion, the property damage exclusion, because the trial court focused on this third-party damages and made that central to their decision. Can you address
yes.
that from your perspective?
Certainly. Some of the ambiguity that courts have found in the J5 exclusion is in the very beginning of the exclusion. It states that the property damage must be to that particular part of real property on which you are working. And they have looked to say, especially in the timbering cases, the third parties, if you cross over a line and are accidentally working on a neighboring property, the courts have said you've caused damage to a third party. That's consequential. That's not where your operations were supposed to be taking place. You were not supposed to be pursuant to your contract rightfully there. You were over the line. And there are third parties involved, and we're going to consider that to be resulting third-party damage that is covered and is not where your operation should have been, not part of the property where you should have been, which is why this case is extremely unique, because pursuant to our operations, we were exactly where we were anticipating being. Our work and what we intended to do was specifically in this location, but as you've indicated, the question is it enough that they didn't have a contractual right to be there?
So I get what you're arguing is it's not that they were in the wrong place, because it wasn't that they were in the wrong place. It was that they were in a place that they shouldn't have been.
Not yet.
In other words, it wasn't that they were in a place that they shouldn't have been because they went to the wrong place. It's that they were in the place they shouldn't have been because they shouldn't have been in that place, period.
Correct. For example, if Al Nair had a contract to gut a King's restaurant and they went to the wrong restaurant and gutted it, certainly that wasn't part of their operation, and they, there was misinformation that was passed around and they went to the wrong place. In this case, we don't have misinformation. We have a project manager who thought, hey, I'm gonna get a jump on this. Everyone's gonna be really happy that we got this done. He thought it would all come out in the wash, but knowing that he had no right to do it. He had the authority to make that call and proceeded on a contract that hadn't been signed yet. So we don't have that ambiguity with regard to the property that we were working on. We were where our contract anticipated us to be. They were doing the work that was anticipated. They were doing the work that a project manager decided it was time to do, all falling within the J5 exclusion.
You've reached, I'm
I'm
sorry, Judge Winkler, do you have a question? I'm sorry.
And I think you already answered my question, Ms. Evans, but assuming all the contracts were in place and everything was copacetic, there still would not be any coverage based on the demolition under the exclusion. Is that correct, ma'am? Does that make sense? Assume that there was a contract and they went in and performed the demolition, and something happened, something went wrong. Under your argument, the exclusion would still prevent any insurance coverage by your firm. Is that correct?
Depending on what went wrong. If it was limited to something going wrong during the course of the demolition,
Right.
yes, it would be excluded by that.
Okay.
All right, thank you, Ms. Evans. Ms. Leffler?
Thank you, Your Honor. What we're here talking about today is whether claims made by a non-customer for trespass, conversion, tortious interference with contract and negligence are covered by a CGL policy. And Your Honors, this is an old question with an established answer. The answer is yes. These are the types of claims that are covered by a CGL policy. What Westfield is trying to do in its appeal, it's advocating to try to create a brand new test, a quote unquote control test. Westfield argues that the Ohio Supreme Court in the ONU case and Custom Agri used this new test to radically change the scope of the coverage grant under a CGL policy. The Supreme Court, though, did not change the rules in those cases. All that it did was clarify them. And the Supreme Court has never presented those two cases as a complete reworking of Ohio coverage law, as Westfield's trying to do here. I want to set the stage for just a moment, and the facts are in our brief, and I won't repeat the entire discussion here, but I think it bears emphasizing whether there is coverage or not in this case has to be analyzed in light of the claims that were actually made. The claims at issue here did not have anything to do with the quality of Al Nair's work. No one has said Al Nair did a bad job in its demolition work. Al Nair is accused of destroying the property of a third party, KRG, the former tenant. It is not accused of doing anything wrong by Weirden. KRG brought these claims, again, trespass, conversion, tortious interference, and negligence. These are the types of claims that have always been covered by CGL policies, and I think it's noteworthy that Westfield has been unable to point this court to a single case in which claims such as these have not been covered. Instead, Westfield says, create a new rule and try to restrict the scope of coverage to so narrow a point that these claims aren't covered. But there's some problems with this. Westfield,
I mean,
yes.
you're saying they can't point to a case, but this is sort of a unique situation. I don't think that businesses normally engage in operations that they don't have authority to engage in.
I think, Your Honor, that's exactly right. This is not a normal or predictable or frequent risk that many business owners face. However, in order to get to the point where there would be no coverage under the insuring agreement, no occurrence, Westfield is advocating that this court adopt a control and foreseeability test. No court in Ohio has done that. When Ms. Evans says this case doesn't have a whole lot of precedential effect, I'll tell you that causes me grave concern. Because in arguing that Westfield, that Custom Agri and ONU fundamentally changed Ohio law on the meaning of occurrence, such that business risks, which no one's ever defined, but regular, frequent, predictable business risks are just simply never covered. They never fall within the coverage grant. That's a huge change in Ohio law, and no court has held that. And that's the test. So I'd like to maybe give some examples and test the control and foreseeability test that Westfield is proposing so that we can see if applying that test, if this court were to hold and this became the law of this jurisdiction and other folks are citing this case and they say control and foreseeability, what types of claims are going to get through? The first thing we see is that this control test won't let through the exact sort of risk that we know is covered by Custom Agri and Ohio Mortar. They were unequivocal, and Westfield acknowledges consequential damages to third parties are covered. This goes a little bit to your question, Your Honor, when you asked, well, if they had had a contract, would the damage then have all been excluded? No, because the Supreme Court has said that consequential damages arising from your work are unequivocally covered. They have said in Custom Agri and ONU, there's no coverage when your work is the damage, but there's coverage when your work causes damage. So consequential damages we know are covered, but
under that, if you're saying, okay, there's no coverage if your work is the damage, isn't that what we have before us?
No, Your Honor, it is not. Again, we have to focus on this case from the claims that were made. The claims that were made against us were, Al Nair, this was my property, and you had no right to be in this building. You had no right to touch any of these things or to demolish them. So no, from the perspective of the claims that were alleged, this wasn't our work. We weren't supposed to be doing any work at all.
So point us to where we can rely on to say we should be looking at the claims and that's going to govern the outcome.
Sure, and that's sort of black letter Ohio law. You look at the defense obligation, you look at the indemnity obligation, you're comparing the claims that have been alleged, and in connection with indemnity, the claims that have been proven, what their damages are, and comparing it. You're kind of holding up, here's my jury verdict form, or here's my settlement agreement, and I'm going to compare it to the provisions of the policy. Here's what our policy says. Our policy says that it's, and Ms. Evans is correct, our policy says that what's covered is an occurrence. An occurrence is defined in the policy as accident. Now, Ms. Evans said that she doesn't agree about our view of the law that intended and expected is what accident means. But that is what the Ohio Supreme Court has said multiple times. The Ohio Supreme Court in both Ohio Northern and Custom Agri affirmed that an accident occurs when the policyholder, when something that is unintended and unexpected from the perspective of the policyholder. And I think something bears noting here.
Well, they're talking about fortuity and occurrence by chance. And if someone is demolishing something, then they expect for it to be demolished. So it seems to me that the outcome that was intended is the outcome that occurred. They expected for it to be demolished.
So that is an excellent point. And I don't know if this was in our briefs or not, but I'll refer the court to Physicians Insurance Company versus Swanson. And the site for that is 58 Ohio State 3rd, 189. And what the court there said was you've got to distinguish between intentional acts and intentional harm, because pretty much every act is intentional. You know, you intend to speed on the roadway, but you don't intend to cause a catastrophic 5-car pileup. You intend perhaps to install a roof, but you don't intend for that roof to blow off in a windstorm and have all kinds of damages suffered by them.
Here they intended to demolish the building and they demolished the buildings. The issue isn't what they intended to do, is that there was no contract and no authority to do such.
They intended to demolish the building, but
the business that was inside the building, yeah.
That's right. And just some points, again, these are our briefs and these are certainly in the underlying record. But we take some issue with the facts as they've been laid out here as well. The reality of what was going on here is that Josh McCall walked into this place and it looked like it was falling down. They had to call the water department out. There was 3 inches of water on the floor. There were burn holes. There was mold. This place looked horrible. And Josh McCall had absolutely no idea that there was any tenant. He walked in and he said, I'm going to do someone a favor because no matter what happens next, this all has to come out of here. That's his entirety of his knowledge. For the upper management folks, they knew only this, and this is what the testimony was. They knew vaguely that there was a tenant that needed to be released. No one at Al Nair knew about KRG. No one at Al Nair knew there was a dispute. No one knew that there was a dispute about possession of that property. They thought this was an old abandoned thing. And the worst thing that would happen to them, if Josh McCall, the worst thing that's going to happen if he does this early, is that they're not going to get paid for it if a contract's not signed. That's the type of risk. That's the type of risk that might be excluded, that would be excluded under the policy, not getting paid for work that you've performed. Or the risk that, hey, you're a contractor, if you do faulty work and you have to fix it, that's not going to be covered. And
I agree with you in engaging in an activity that you don't have authority to do, even if you think you're doing someone a favor, you're taking the risk that you're not going to get paid. But you're also taking the risk that that person is not going to be keen on this so-called favor that you've done.
I think that's right. And the distinction is what's covered by insurance and what isn't. Intentional acts, and again, this is Physicians Insurance Company versus Swanson, it's custom agri, it's throughout Ohio case law for decades. You are focusing on whether there was intent to cause specific harm to an actual, to a claimant. Did you intend that specific harm? Did you intend or expect that a specific harm? And that's the standard.
Well, the
That's-
harm that was intended was, I mean, it was intended to be demolished, and that's the harm. So any damages, any complaint is based on that harm, you know, because the harm could have, you know, the harm could have been bodily injury, it could have been, but, you know, in this case, the actual harm is exactly the act that was engaged in. And so anything, you know, any complaint of is, you know, make me whole because I've lost this and I wasn't supposed to lose this.
The distinguishing factor is the harm versus the damages. So the act versus the damages. The demolition, you can say that was intentional. Josh McCall intended to demolish. He had no intention or expectation that he would cause harm to a third party, to KRG. He had no expectation, and under Ohio law, that's what's covered. Custom Agri and O&U, effectively what they did was they said, we're going to look at this and we're going to say that when a contractor performs defective construction and the customer comes back and claims repair or replacement, make good the work that you did for me. When that happens, that will never be an occurrence because the court said that you're always expecting or intending the harm. That's what the Supreme Court did there. It did not take us so far as to fundamentally change this string of Ohio cases that have existed for a decade.
Ms. Leffler, you have reached your time. Mr. McLaughlin, sir, you still have your 3 minutes.
Thank you.
Thank you. I just want to follow up on a few items Ms. Leffler was talking about. The issue here is timing. Ms. Evans has said Beaver Dam, Acuity, Metropolitan Design don't apply because they were different locations. Well, this case, they jumped in early. It was the same location, but they jumped in early. It was premature. By jumping in prematurely, it's the same thing as when it was a different property because they were affecting rights that belong to a third party. And that's what insurance is intended to cover. It's intended to cover damage to third parties. The Westfield's attempting to avoid coverage based upon a principle and an exclusion that's tailored for claims by customers against an insured for property damage. And there's no case in Ohio.
But aren't they arguing that it's all centered on accident? So it isn't about they don't want to cover it because it's a third party. My understanding is that it's all centered on occurrence, and then that goes to accident, and now we're getting into the Supreme Court definition.
Exactly. And the accident here is that they intended to destroy the property, just as in a number of cases where you intend the act. You don't intend the harm. They didn't intend the harm of damaging and destroying a third party. They jumped in and damaged somebody else's property. They thought it was abandoned. They thought they were doing somebody a favor by destroying this. That they did not appreciate. They were harming a third party's right. That's the difference here. In the Ohio Northern case and the Custom Agri case, that is workmanship. The quality of workmanship of a customer's property. It's not damage to a third party. And that's that control that the court is talking about. Control over the damaged item that your work is not what it promised to be. They did a great job of demolishing this work. The accident, the mistake was that it was a third party's property, not their customers. That's the difference in this case.
But you know, all the cases, again, I have yet to find a case in which the defendant or the plaintiff, the business entity or the insured, I should say, was engaging in something that they didn't have the authority to engage in as a business enterprise.
And that was a mistake.
And
That
so
was
the accidents were, are always they're still engaging in proper activity under their business umbrella, and then the accident flows from there.
Well, let's talk about Beaver Dam. Beaver Dam, they went in, they intended to chop down those trees. They intended that harm. The mistake was it was somebody else's property.
Right, but it was all because of a fraud. It was something
that was acuity. Beaver Dam was
Okay.
just a mistake. They went beyond the property lines. That
Okay.
was just a mistake. They went to third party. That's why the same thing is here. It's not that they went beyond the property lines. They did it prematurely. They jumped in before they had the right.
Right, but Beaver Creek, they believed that they had the authority to get to that additional property, or to get that additional frontage or whatever acreage, right? They believed that that was part of the contract. In this case, there's no contract, so there's no, well, I believe that I can do this or anything like that, and getting back to a point that was made earlier, it's like looking at the claims. Well, okay, so we see trespass. Well, you can't have trespass unless there's damages. If there's no damages, you have no trespass claim.
And I'm sorry, yeah, that is correct. Well, you could have a loss of use claim, and I'm sorry, could you explain the relevance in this particular? So you had a trespass, and you did have the damages in this case. You have the destruction of the property in this case.
And again, the destruction of the property, it is exactly the act that the person was engaged in.
Correct.
But not something that's accidental. Well, I meant to not destroy the property, but I destroyed the property. It's like I meant to destroy the property and I destroyed the property.
Just like in Beaver Dam, the intent was to destroy chop down those trees. The mistake, the error that's intended to be covered by insurance company are those mistakes. When you make a mistake and you damage or destroy property, they didn't intend to harm the interests of KRG in this case. They thought this was abandoned, useless property that was flooded, so they jumped in early without the right to do so, which caused the trespass, but they didn't intend the harm.
So here's my question. If we were to affirm, then can you share a scenario where a business entity engages in something that they're not authorized to engage in, that they're not under contract, and they go ahead and do it, and that would not be covered by an insurance claim?
I'm sorry, and I want to make sure I understand the question. That there's cases, maybe I'm misunderstanding, but there's cases, and have been cases forever, where the old oil tanks in houses, they take out the tanks, they cut off the line, but an oil company intending to fill that oil tank on the outside goes in, fills it up. There's no tank inside. So they intended the act. They intended to fill that, but there was nothing inside. So the intent was there.
But they had the authority to fill that tank.
Well, they went to the wrong house. Their customer was in house A.
Yeah,
they went to house B.
We're back to cutting down the wrong trees on the wrong property, and that we know that got covered because that was defined as an accident. And they were acting under the authority of cutting down trees. They just showed up to the wrong property, thinking that was the right property. Or the other case, they went further than what the contract had allowed for, but thinking that was still under the contract. Because it just seems, I mean, under your position, then it seems that anytime a business engages in something that they're not authorized to do, and they get sued because of that the insurance company should now cover that.
If it's a mistake, if it is a mistake, they didn't intend the harm.
Well, the mistake is they took a business risk. So, that's something every time, well, I took a business risk, I took a business risk.
Well, the business risk is traditionally in Ohio has been limited to a customer's complaint as to the quality of the work that was performed. That was the control that the insured has. It doesn't have control over third-party damages. And that is the control analysis the courts have been doing in Custom Agri in Ohio Northern. It has never been extended out to damage to a third party that was not involved in that contract or the proposed contract.
Mr. McLaughlin, you are at your time, sir. Thank you.
Thank you.
Ms. Evans, you still have your 3 minutes rebuttal.
You're
Yeah.
muted.
Sorry about that. Just briefly, one of the statements that was made by counsel for Al Nair was, these are all the allegations that were in the complaint. There was trespass and intentional and a lot of allegations. I do want it to be clear, Westfield accepted the defense of the underlying litigation. They looked at that complaint that was filed and said, there are enough things thrown in here and allegations made that certainly there is a possibility that there is coverage. We'll provide a defense. We're then going to litigate the coverage issue, and agreed that we would set those coverage issues aside. There was a settlement of that case and an agreement entered into that has brought us here today to litigate that indemnification piece. That standard of what were the actual facts. We're looking beyond the pleadings now. We're looking to what Al Nair knew. Al Nair had business practices in place that knew that they couldn't proceed without authority, and that authority had to be a written contract in the hands of their project manager before they could proceed. They knew, we did the discovery, they knew that there had to be a release of the lien obtained by their customer. Weirton Medical Center couldn't proceed until the landlord got the release and that their contract was finalized. We did that discovery. We went to the point of identifying what are the actual facts, the knowledge. What did you know when you went forward with this work? Was there some miscommunication? Was there some failure to know something that is truly a mistaken act?
Well, Ms.
And
Evans,
what we just
can you
Yes.
just address, so obviously their position is that the control test or the business risk analysis isn't the law in the state of Ohio, and that this was a mistake, which you can say is an accident, which is an occurrence. What's your response to that? Is this in fact not the law in the state of Ohio?
Well, what I would point to in our brief on page 19, I refer and I have a quote to the Supreme Court decision. And what it says is that contractors' business risks are not covered by insurance, but derivative damages are. The key issues are whether the contractor controlled the process leading to the damages and whether the damages were anticipated. And that's our argument in this case. I do disagree. I disagree that the standard that the Supreme Court talks about in those two decisions is a Swanson's intentional act. Rather, what they've looked to is the issue of fortuity. But what is fortuity? How do we decide if something's fortuitous? And the facts that they've directed us to look at are those of control. And those of anticipated damages, because the more something is controlled by you and the more something is not unforeseeable, the more it lacks fortuity. And I believe that the state of Ohio has specifically talked about those facts and those issues in crafting what is an occurrence and an accident under Ohio law. And we would ask that this court look to those decisions and look to the specific factual discovery in this case as to what Al Nair knew, what it controlled, and the decisions that it affirmatively made to lead to the specific damages that it intended to do. And for that reason, we'd ask that the decision be reversed and that a declaration be entered that the policy coverage is not triggered.
Thank you, counsel. Thank you all the attorneys. Very interesting issues. We will thoroughly review the record and issue a timely decision. Thank you again for your arguments this morning.
Thank you.
Thank you.
All right, then moving on to the next case on the docket. It's C19-0541, Amanda Brenham versus Matthew Brenham. Good morning.
Good morning. Good morning, sir.
All right, so both the Branhams are on. Ms. Branham, you understand that you have 15 minutes to argue this morning.
Yes.
Would you like to you can save some time in rebuttal? Would you like to do that?
Yes.
How much time would you like to have in rebuttal?
5 minutes.
5 minutes. Okay. So you have 10 minutes. I'll I don't know if you watched the first argument or not. I'll kind of just let you know when you're getting close to your time, and then
All right.
I'll just signal you. Okay. So
Okay.
go ahead.
First, I'm asking the court to reverse the decision of the domestic relations court in the custody of our minor children. They failed to prove substantial change of circumstances and what would be in the best interest of the children. The judge failed to take into consideration the parenting investigation in which the court ordered, and she violated all of the ROCs. Nothing was followed in order to determine who would be best suited for custody. She also failed to, I filed a motion for facts, findings, and conclusions, and she failed to provide those. She stated that she already did that in the order that she submitted, but there is no reasonings in her order that she gave. Everything that went on during the hearing all was in my favor. Everything supported that I was better fitted to be the residential parent and have full custody. The same as the parenting investigation also recommended that I be residential parent. Their father, he refuses to communicate. He refused to help financially. The courts failed to uphold any of their orders in any financial support. They put $1,000 of child support on me, making $10 an hour, but yet failed to even make him pay half of childcare that I requested. The entire time during the court process, the judge continuously made comments to him about not communicating and the situation with his girlfriend. She has trespassed me from their property. She has tried to threaten me with telecommunications harassment. She has tried to get a restraining order against me. She has filed numerous reports that I stare at her children when picking up my children from her residence where he lives. It's caused a strain on the relationship. He has made numerous reports to a JFS as well as people associated with him, such as the kid's therapist when in his care. And the latest was a doctor. I actually haven't seen my kids in 2 months right now because of this. There has never been any evidence supporting any of this. My kids, when they were in my care for an entire year, I financially supported them myself. I got them to and from school myself. I initiated all the parenting time that was court ordered, as well as the phone calls. She even used the fact that my daughter was not in therapy because I had withdrawn her from therapy. It was never originally ordered for my daughter to go to therapy. Later, that was ordered for my daughter to go to therapy, and I'm the one that initiated all of the therapy sessions after that fact. He refused to, even causing my oldest to miss school because he would not help me get them to and from school. I was going from Middletown, Ohio down to Cincinnati, which in traffic can take you about an hour and a half each way. I was doing that myself with no help from him. I requested from him that we take the kids out, take my youngest daughter out and put her in school therapy so she didn't miss school and my oldest could stay in school. He denied that, and the second he got custody, he took her and put her in his district in school therapy. It just seems like everything that he's done is just to get back at me. It's not in the best interest of the children. I don't feel that the judge took any of this into consideration. I've done exactly what the court has ordered me to do. I have followed everything that they've ordered me to do, and he has refused to do so. He won't even speak to me about my children. He refuses to answer text messages. I've even had to have it court ordered that he respond to text messages. Even when it comes to school, if he can't pick my daughter up, he calls the school rather than me. Even causing my daughter to sit at the bus garage for like an hour until he got there one day because I was never notified. I definitely don't feel that the judge made the decision based on the law and based on what is the best interest of the children. It's continuous. This was settled in 2018. It started in 2017. We are still going through court. And I feel that domestic relations court has been very one-sided for some reason. And I don't think that there's any reason whatsoever that I should have less than 50-50 custody of my children. I did all the communicating. I did everything that I was supposed to involve him, even in parenting. Well, in 2017, when they awarded him full custody, he hid the children for an entire month from me. I didn't know where they were until I went to court and got visitation. He refused to let me speak to my children, and he refused to let me see them. I had to track my oldest down through public school systems. And that has been continuous. I've missed my daughter's birthday. I have missed half of Mother's Day and had to call the police to try to help me get my kids on Mother's Day. On emergency contact forms, I'm always left off. I just recently got a court order to put me on there. He puts his girlfriend and her family above her own mother on school forms. I feel that I have continuously filed motions for alienation. This is not a parent that is supporting a healthy relationship with the other parents. This is trying to knock one parent out and substitute them with a fiance. He's even went as far as trying to charge me $800 for half of childcare, which was his live-in fiance watching our children. Not a daycare. His fiance, who was there watching his other daughter as well from his previous marriage and our kids, he tried to take me to court for $800 to pay her to watch his kids. And I mean, like I said, I've followed the court orders. I've done everything I feel humanly possible. I've tried to communicate. We used our Family Wizard app. I tried to turn in a lot of those documents to the judge in the case, and she stated that that's our notes, that's not evidence. So I was unable to provide that, but that shows specific dates and times of anyone who put anything in a calendar and that they did it in a timely manner when they were supposed to. I mean, I feel like I pretty much explained everything in my brief. I don't understand why this decision was made. I feel like I'm being punished for what he's doing. My kids have never been abused. They've never had a bruise. They go to well child checkups every year. A daycare has never reported me. A neighbor has never reported me. And only when they are in his care. I provided evidence. I filed a motion to stay until I got in appeals, which has taken me almost a year at this point. In the motion to stay, I gave Judge Searcy evidence that his oldest daughter is in therapy. She is suicidal, and my kids have been left alone with her. And even recently, there have been police reports filed that she purposely tried to hurt her 2-year-old brother with glass that she left. I also provided evidence of messages between his oldest and her mother stating emotional and psychological abuse. She had been locked up in Children's Hospital twice for being suicidal. And most recently, I had to make a report to JFS because my kids came to me and reported that his oldest daughter had either made the comment she wished everyone in the house was dead or threatened to kill everyone in the house, and they were locked in a bedroom. I've shown all this evidence to the court, and it's literally just ignored. I didn't get a hearing. I didn't get to see a judge. JFS did not report this to local law enforcement as they should have. Sitting right now in Judge Searcy's court, I am 2 months without seeing my children when my child didn't have so much as a bruise.
Ms. Brennan, you've
Yeah.
reached your 10 minutes. If you'd like to
Okay.
reserve your rebuttal time. Thank you.
Okay.
All right. Mr. Brennan.
Hello, sir. Good morning. I feel like the judge weighed heavily in the best interest of the children and the credibility of everything that was presented. Yes, Pat McGill's report did say that Amanda should be the parent. However, he didn't say anything negative about me, but he mentioned in his report of Amanda's anger outburst, even in his room, which Amanda has shown in the courtroom as well. And, you know, since then, since being in the courtroom, like 2017, I was awarded custody. In 2018, and we had a GAL involved, we came to an agreement for shared parenting. And we attempted shared parenting, and, you know, I had to have it court ordered that Amanda not miss another appointment, therapy appointment with Madeline, with a therapist, because the therapist informed me that if she missed one more appointment, she wouldn't be able to come back to therapy again under her care. And I didn't want that. So Judge Searcy put that in the court order for her to do that, and me to schedule the appointments, because I was taking her the entire time before that. So, and I attended some sessions after that, but I was always in contact with all therapists. And, you know, now, even, you know, since then, we've been to court. In 2018 was shared parenting. 2019, I obtained sole custody again because we went in front of the judge, and she asked us, because neither of us was communicating very well, and there was a lot of issues of her leaving the children home alone, which was reported. The police were there, and she made it home because my daughter texted me rainbows, which was our code word at the time, if she ever felt unsafe. And she texted me that, and then she let me know that she's home alone again with, and, you know, she's a young child at the time. And then our other young child, which I believe was 4 at the time, was home alone. So we were on our way to pick her up, and I called the police to do a well check while I'm on my way. And then Amanda happened to call and find out that the youngest child told her that daddy's on his way because we're home alone. So she went home to get them. So since then, all that, we've been in court in front of the judge. JFS was involved because the Cincinnati Children's called Cincinnati Children's called CPS because Amanda threw a glass bowl, and hit Madeline in the back. I took Madeline in for a rash that Amanda even texted me about, saying, "Hey, she has a rash." So I took her to the doctor for the rash, and Madeline told the doctor about that incident. And then it was investigated. It was open, and whenever we went to the courtroom, we had the JFS worker and the kids therapist subpoenaed, and they were willing to show up at court, so they were there. And then they all came to an agreement outside of the courtroom of Amanda being on supervised visitation and going to therapy, and different instances, whatever JFS was going to assign for her to not have supervised visitation anymore, which begins tomorrow for her supervised visitation at the family center. I believe it's in Oakley. That they agreed for her to have supervised visitation, and we all went in front of the courtroom, or in the courtroom in front of the judge. Amanda agreed to everything. We read it out loud, and she signed it. You know, she signed the new order saying that she agrees to have supervised visitation. And so I feel like, you know, all the evidence was there that was presented. And the main concern I feel that Judge Searcy had was for Amanda's anger issues. And because it's not the first time it's been reported about her throwing things The children's reported multiple things being thrown, her breaking her TVs and her cell phones. And I know this behavior because I lived with her before, and she would throw things and put holes in the wall. And one instance that the girls reported also was that she had a gun with not a lockbox. Madeline, she's 6 now, but it was before she was like 4. Described the gun and the bullets, and Kaylee, she's 12 now. She said, you know, don't play with that. That's a gun. It's dangerous. And then they said that their mother said, it's okay. It's not loaded. Well, that's not okay either, because what if it's not loaded? What if she goes somewhere else where, you know, the gun could be loaded and she just thinks it's not loaded? Like, it's kind of scary to me. And so, you know, I just, and back to, I guess I need to address my oldest daughter. Yes, she has she has depression, she has anxiety, but it's all umbrellaed under PTSD is what her therapists say. And it's all caused mostly by Amanda and the abuse that Samara had while in her care while I was at work. I didn't know about until 2015, which is why I left her and then filed for divorce after, because I didn't want my kids to live in that kind of environment. And, you know, the kids have never missed each other's birthdays as well, except for this past one, whenever I was supposed to get Kaylee, and I asked, and my attorney asked Amanda if I could get both kids for the birthday, and she didn't allow me to have Madeline. And the day before was whenever the bowl was thrown, so I'm assuming that's why. But on Sunday, the day after of Kaylee's birthday, I was able to get the kids, and that's whenever Madeline reported to the doctor, and that's when Amanda hasn't been able to see the kids since then, except for a Zoom call with Madeline. Kaylee, she doesn't want to Zoom right now, and she only wants to talk every other day, or, you know, not as often, she says. And I think it's because of the intimidation that she feels from Amanda, because, like, her therapist has been great with her and her emotions and feelings, and getting her to understand that she's allowed to have those emotions and feelings and be respected even by her mother. And therapist has contacted Amanda multiple times. Amanda's not really been involved at all with that. She's seen her, I think, once in person and once on a Zoom call, and she's been their therapist for nearly a year now. Yeah, and Pat McGill, of course, with him saying that she should be the parent, but also displayed his concerns for her anger. You know, I know the court, you know, that doesn't define, like, they're not obligated to take what his recommendation is. So it was basically just her and I going in the courtroom because we represented ourselves in front of Judge Searcy. And Judge Searcy just weighed heavily in my favor due to the best interests of the children and their safety, which I feel is obviously the right choice, since now that Amanda has supervised visitation that she agreed to due to Madeline getting hit with a bowl, and hopefully recognizing that she needs help with her anger issues towards the children. She can be mad at me all day, but in the end, it's the kids that matter. So I think that's pretty much all I have. All I have at this time.
All right. Thank you, Ms. Brennan. Ms. Brennan, you still have your rebuttal time.
Okay. as he mentioned, there was a GAL involved in the case. He constantly has reported me. He's the one that makes the reports of me throwing. He's never been in my home. He's never seen inside my home. He's never seen me with my children ever since we separated. So, I mean, it's all hearsay. You're taking what children are saying. The judge even had told him to quit questioning the children. What happens in my home stays in my home. If they are not safe, he can teach them to call 911, as which he said he had done. The guardian ad litem expressed no concerns with my home, with anything in my home. There was no holes, there was no broken anything. My kids had their own beds. He mentioned in the report that Patrick McGill mentioned anger. What he mentioned was I grabbed my daughter's wrist. I believe she was 2 at the time. He did not articulate that I hurt my daughter in any way, shape, or form. She had a wooden basketball toy where you got to throw the ball in the hoop. She's 2. We're in an office. There's 3 of us. I grabbed her arm because she's flinging it around and tried to get her not to fling it so hard. She's 2. It's a wooden ball. Anybody that has kids could know what that could do. She's going to end up tossing the ball or tossing the toy. He never said I had any anger issues. He recommended anger counseling, which I attended, and they said was situational due to the emotional, mental, and physical abuse from my ex-husband. The birthday situation, I asked my daughter, it was not court-ordered that she go. I asked her if she wanted to go. She said she wanted mommy Maddie time. Therefore, I didn't force her. I took her out with her sister. I asked if she wanted to go. She said no, she wanted to stay with me. I wasn't going to force her to go. That was on August 1st. He did get them on August 2nd for his vacation. So me keeping her because she was supposedly hit with a bowl, there would have still been a bruise there on the 2nd. There was no bruise on my daughter. No bowl was thrown. There are allegations again from him. And none of the other kids were there except for his oldest. His girlfriend's kids were not there. They didn't have a birthday party. They celebrated her birthday later. So I did not see that as a big deal. There has never been an open JFS case. Reports have been made. Obviously, like he has said, no reports were ever made until during the parenting investigation when Patrick McGill asked him if he had ever made any reports to 2-for-1 kids, and they haven't stopped since. During our last court order or our court appearance, before the last JFS report was made, Judge Searcy made the comment that I told her no more cases nothing's been reported since he got custody. He turned around and she said that if a new case were opened by a mandated reporter, then, maybe that would be a reason, because he had already filed a motion to suspend my visitation at that time and no reports had been made. A few days later, this report came in. That's been the pattern throughout the whole divorce. As I mentioned, the court order was not, or the therapy for my daughter was not court ordered. I didn't feel that she needed it. I felt that that was within my rights as a parent to make that decision, and I did. Once it was court ordered, I did take her, and those have been turned over. I believe I may have put some of those in with my reply brief. I'm not positive. All of that can be covered by the therapist. I did agree to the supervised visitation as advised by my attorney because she said after a couple of visits, I can get out of this and get the kids back in my home once we get the reports from this center showing that there is nothing. The therapist, I do communicate with her through Class Dojo quite often. I actually just messaged her today and a couple of days ago, and she sends me reports on every session with my children. I have every one of those so that I can see what their therapy session was about, how they were acting, if there's any concerns, anything like that. I've also met with her in person. I've also met with her through Zoom. He makes claims that the kids were left at home alone. I have had one babysitter talk to the police the day that he called them. I had literally just been at my daughter's soccer game, which is on video, earlier that morning. I had my mother who has kept my kids, and I also had my babysitter who was our neighbor. She testified that she has been there with the kids as well. My latest babysitter just moved. My newest babysitter is ready to go to court again. I actually, because of the accusations and they continuously went on, I mean, I can't live my life in peace because of this. It's like I'm constantly fighting for my kids nonstop. My work schedule was actually changed from 9 a.m. to 3 p.m. So I would take the kids to school and pick them up. There was never any time when I had the kids in my care and I was residential parent that I ever worked. I quit working completely so that I would have a work schedule to reflect that, to protect myself. I think that's just about it. He mentions anger in the courtroom. I'm not sure what I mean, if anger is me crying because I'm upset because I'm constantly fighting for my kids and they're constantly being taken by these court systems, when I've never had an open investigation by JFS. My kids have never been to the emergency room. They've never had a bruise, stitches, a broken bone. They were perfectly fine. I will say that my daughter has started refusing to talk to me on the phone. Before that, everything was fine until all of this happened. And they are put in the middle because of all of this. Before, it was because he refused to communicate. So I would constantly have to tell my kids, you have to go talk to daddy. You have to ask him. I've asked, I'm not getting an answer. If this is something you want to do, then you have to go talk to him. And that's not how this should work. And he doesn't understand that. The kids are constantly put in the middle because he refuses to communicate. During all of this time,
Ms. Brenham, I'm sorry. I need to. You have reached your time.
Okay.
And so first of all, I want to say I know that this is difficult for both of you. I just want to commend you both for doing an effective job this morning. So we will take the case under submission. So what happens now is we thoroughly review the entire record. We will apply our standards of review to it, and we will issue a timely written decision, which you will get notice in the mail. Okay. So I wish you both the best of luck. And again, you will receive our decision in the mail. Okay.
All right. Thank you.
All right. Thank you.
Bye.